I'm very grateful to the colleagues here at the table with me. I'm also grateful to other colleagues who are here, both heads of courts in the Superior Court as well as heads of courts in the lower judiciary who are here. I did ask that some be here so that if there are questions that relate to the lower judiciary, they can also be part of this and they can assist with dealing with those issues. So thank you very much to everybody for being here. But I must say that I see more judicial officers and OCJ staff than media. But nobody must think that the Chief Justice decided to fill up the room with judges and magistrates so that the questions would be favorable. Okay, thank you.
Thanks. We'll just do one question at a time, please.
Thank you. It's Kani Mapanga from SABC News. The question is really for the JP of the Gauteng Division, Judge President Mlambo. Just for reporting purposes, if you go beyond the figures and try to explain in the overview of this current year as to what could be cited for the failure to reach that target of finalizing those matters, the criminal matters in the division, what would you attribute that to? And then, of course, I do have a selfish question. I've been covering a number of the judicial conduct tribunals and some of the complaints. We know that a number of those judges did come from the Gauteng division. Has that had an impact on the performance of the judicial functions, as well as the perception or public confidence in that particular division when performing your judicial functions? Thank you.
Let me start with the last question. The judges who've been suspended because they are in the Judicial Conduct Committee have been replaced by acting judges. But that's acting judges. They don't have the level of expertise and experience of those permanent judges who are out there. So the impact is not that big, but it is there. The elephant in the room about the first question you asked about why we failed to finalize those criminal matters as well as close up all those backlog matters. If you had time and profiled all those cases, you'll find that it's not cases that involve one or two people. They involve a lot of people. Sometimes, there's a trial that was finished by acting Judge Makamu. It had 11 accused people. It took him 5 years to finalize it. During the process, accused people and the lawyers have established tactics that ensure that the court does not finalize the case or does become productive in terms of ensuring the trial proceeds to its finality. So that's the major reason why in Gauteng in particular, because in the roles of the two courts, you have a lot of those cases that involve multiple accused, and they employ those tactics very effectively. And as judges, we are powerless to try and force them to say, no, I'm not going to allow that. We must run with this, we must run with this. So that's the major reason. It's not that judges are not there. Judges are there, they are available, they are ready and able and willing to sit, but they are prevented from running with these trials because of that.
Thank you, JP.
Thank you. Thank you. My name is Mbegazeli Benjamin and I come from Judges Matter. Thank you, first of all, Chief Justice, and to all the judges present for the wonderful performance that comes out of the report. Surprisingly, a lot of the questions that I had were answered in your address, Chief Justice, so thank you. But I still do have a few, but I'll limit it to 3. One of which comes from the last question on the judicial conduct generally. Last year you had mentioned that you and the Minister had spoken about the amendment to the JSC Act. So could you maybe give us an update on how far you are when it comes to that? But also, Section 10 of the JSC Act requires that the Judicial Conduct Committee report on the number of cases filed, how many have been finalized, how many are still pending, and all the details of the operations of the conduct system. That report is missing from this report you delivered today. I don't think it has ever been delivered in the 10 years since the JSC Act, a lot more. So maybe could you give us an update on where that report is? The last one is on acting judges, which Judge Mlambo has touched on. In Gauteng, they use a whole lot of acting judges. And from the Rationalization Report by Justice Museneke, there's a whole lot of acting judges being used in the system. There are two issues with that. One is that there is a crucial need for more judges. So the question is there engagement with that rationalization process at a more qualitative level? There is some engagement in terms of submissions being made, but is the judiciary meeting with that process? Because ultimately it's supposed to lead to more judges. The last point is on the policy for acting judges. That has been a concern, particularly from the legal profession, that the process of appointing acting judges is opaque, is transparent, open to abuse. So is there a policy that is in the development phase, and how far that policy is? Thank you.
Thank you.
I will answer three, and then there is, I think, one that you said you related to Gauteng. Is that right? Okay, I'll answer the ones that I thought were not confined to Gauteng. About the amendments to the Judicial Service Commission Act that, if passed, should solve this problem of backlogs with regard to judicial conduct complaints. There hasn't been any interaction or discussion between myself and the minister after I sent him the proposals, other than a casual discussion at the JSC. Well, I think that it wasn't last year, it would have been earlier this year when I announced that I had sent that proposal for amendments. We had identified that the solution to the backlogs is to expand the pool of judges who deal with judicial conduct complaints. And indeed, I believe that that will solve the problem, because at the moment, in terms of the Act, the maximum of the judges is 7. And there are 248 whatever judges. And those judges a number of those judges would be judges who are in active service, who have got their own caseload in their own courts. We do make use of retired judges as well. But retired judges also, some of them have got their other commitments. But if the amendment is made, what it will mean is that the Chief Justice or Chairperson of the Judicial Conduct Committee can basically have as many as 50 or even more judges who could be part of the Judicial Conduct Committee as additional members of the Conduct Committee, and they would share the burden of resolving these disputes. So I guess that part of the problem from the minister's point of view is that this proposal came sometime this year, and this year we all know the politicians have been busy with elections and so on. So I will raise the issue with the new minister so that they can take a view whether they are going along with the proposal or not. And if they go along, it shouldn't really take too long before that kind of amendment can be passed by Parliament, because it would be non-controversial, really. So that is that. About the judicial conduct reports in the Annual Judiciary Report, One, let me say that there may be something in the report, but not much in relation to the Judicial Conduct Committee. But that is because I think some time back it was decided, and I don't know if it was me, but it may have been me, decided that the proper place for that information, for that report, is not on the Annual Judiciary Report, but it's on the JSC report, because the JSC is required by law to submit an annual report to Parliament about its activities, and of course the Judicial Conduct Committee falls under the JSC. So actually, I was given last week the latest draft of the JSC report, so it should contain that this matter information about the JCC. I know that you were here last year, and I think you were here the other year. There was a concern raised by somebody. I don't know if it was I think one of the journalists, that the information that is given, I think in the JSC report about these judicial conduct matters, is not adequate. And I think I had indicated that there is no reason why we can't give more information. So I will have a look at the draft and see whether it has enough information. So that's what I can say about the JSC reports, judicial conduct reports. And then about the policy on acting appointments. There was some delay sometime last year and early this year, but ultimately the judiciary did go back to the minister and made comments on the proposals that he had made. So we finalized the issue of comments on the policy that he had prepared and suggested. We were now waiting for him to indicate which ones he has accepted, which ones he hasn't accepted. But by and large, there was nothing seriously controversial in what the minister had proposed. So it may be that now that he's no longer in the Ministry of Justice, there's a new minister. It might take some time before the new minister is familiar. But at some stage, before the end of the year, I would expect that it would be out. JP of the biggest division in the country, maybe I was wrong to think there was a question that was directed at you. But you will speak for yourself.
Thank you, CJ. I was trying to check if JP Tlaletse could answer the question about engagement with the committee, because we collaborated in terms of preparing a response. Thank you.
Okay, thank you.
Thank you, Chief Justice and colleagues. We have seen the report of the Rationalization Committee, phase 2 thereof. We have drafted our report that we send. We take issues with the recommendations that have been made in that report. The fundamental difficulty that we have is that the whole process is driven by the executive. It would have been better if the judiciary on its own is the one that drives the rationalization process. There are issues relating to recesses that they should be done away with on the basis that it's a relic of our colonial past. And what is an anomaly is the Constitutional Court is not a relic of our colonial past. It came in the new constitution, with the new constitution. So there are several issues that we have taken up with the committee. We've called for a meeting to meet them so that we can iron out whatever differences are there. But as I say, fundamentally, focus should be on institutional independence of the judiciary, and the rest can then fall in place once the judiciary takes its active role on these matters. That will also include the budgetary issues. Maybe there will be a question later on that. Let me not go beyond that. Thank you.
CJ, let me just add to that. Thanks, JP Tlaletsi. I think one fundamental issue we take issue with in the interim report is, especially in Gauteng, when we made our submission, we gave the committee a lot of data about why we're using so many acting judges, and we believe we motivated why we needed, at this stage, not less than 20 additional judges to deal with the work. To our disappointment, the committee didn't deal with that data. They sent a template to all court managers to fill, and they are using the information that came out of that template process to file this report. But one major recommendation they are making is, instead of appointing new judges, they are saying we need to develop an IT tool that determines the weighting of the work that comes to the courts before they can decide whether we need to appoint more judges or not. And we've criticized that.
Thank you.
The next question, please.
Now, if there are more questions, I'll direct them to my colleagues. So you can ask, now you can ask difficult questions.
Please go ahead.
Good afternoon, everyone. My name is Zoleka Kotashe from the SABC. Chief Justice, unfortunately, this question is for you. I'm here. Unfortunately, this question is for you. You were speaking about the performance of the Constitutional Court in this financial year. You mentioned that in the last report, the performance or the set target was 70%, or that's the performance that was recorded by the Apex Court. But we also, in this financial year, you recorded 55%. I wanted to know if, because we are coming from an electoral period, where a number of political parties or applicants also sought the intervention of the Apex Court, and some of them seeking direct access as well. Could that have had any impact in the performance of the Apex Court? Thank you.
Well, the period in respect of which we were reporting is 2022 to 2023 financial year, 1 April 2022 to end of March 2023. So while I would have loved to grab the fact that there were election matters and so on, so I can't, because it relates to a year when there were no elections. But we are still trying to establish why there was such a big difference, because in the previous years, despite the fact that the target was 70, we didn't go up to 55, we didn't go below 60 actually. So we're still trying to establish exactly what the cause is. One possible explanation, but I say nothing about its merits, might be cases that might be the rescission applications, because from a certain time we began to have a lot of rescission applications in the Constitutional Court. But I'm just thinking, so we are still investigating as to what happened. But we take responsibility for our performance. Where we did not do well, we accept that we did not do well. And we want to see why we didn't do well. But when people look at the year when we didn't do well, they must also think about the years where we did very well. Thank you.
Thank you, Chief Justice.
Good afternoon, Chief Justice. My name is Tariq. I'm from Business Day.
I just repeat, I've got a lot of capable colleagues here.
Unfortunately, this first question is based on the remarks that you made in the opening. It's sort of based off what Mbeki was talking about. The on-bank requirement that you mentioned, can you just briefly indicate where that currently stands? So where that currently is happening in terms of talking to the executive and so on? And just also, I'm not sure if this was covered, but can you also indicate what has been done for the courts in terms of, for example, providing courts with Wi-Fi access to databases and so on? Because I know that's been a problem for several judges in various divisions.
Well, let me start with the last one. There have been all kinds of challenges when it comes to anything technological. There have been all kinds of challenges. Wi-Fi you would find, but sometimes there are challenges relating to it, and you're not sure today it seems to be working, tomorrow it's not working. But the experiences of different courts are not the same. So I will invite other colleagues to share their experiences. With regard to the N-Bank issue, we have, I sent documentation to the former Minister of Justice some months back. He has not come back to say whether within the executive they have discussed it. And of course, maybe part of the problem was that politicians were busy with elections this year. So he hasn't come back, and but I'm hoping that the new minister will soon look at it and be able to say they agree, they'll pursue it, or what the position is. Thank you. Anyone who wishes to talk about technological challenges, including Wi-Fi at the courts? Oh. Oh, you see, he's retaliating because you pointed at him last time. Now he's pointing at you. Well, everybody will get a chance.
Thank you, Chief Justice. I think the Wi-Fi access issues are a thing of the past. In the last 2 months, I know the OCJ has upgraded almost all the courts' Wi-Fi systems. I can give you an example with the Supreme Court of Appeal. I think they were on 10 megabits per second. They are now on 80, if not 50. I think it's 50. Yeah, they're on 50 megabits per second, and that has improved. So, and those upgrades didn't come cheap. That's why we had to wait. But with those upgrades happening, it has given us the confidence to roll out court online and case lines, which we are rolling out more in earnest. And that will also add to the efficiencies of the courts. So, and in any way, I'm talking about court-based Wi-Fi access. The OCJ also refunds judges when they use their own Wi-Fi tools or Wi-Fi access. So I don't think it would be correct for anyone to still complain about that in this day and age. CJ, can I go back to a question that Mr. Benjamin asked?
I wonder whether you could just keep it at the back of your mind and don't forget about it, because I would like to also give maybe colleagues in the lower judiciary and others to say something about technological challenges, if any, Wi-Fi, whether they also have no problem now and so on. But also other colleagues who might wish to say something. JP from the Kingdom. Do you want to say something?
I can, CJ, just on the court, the inefficiencies,
Yeah.
particularly about the backlog and criminal matters, because Gauteng was not the only one that did not meet their target. I'll just make a quick example. For instance, in Devon High Court, we have got 4 criminal matters, 4 criminal courts, but we have 2 long trials, the Gumede, the Del Vecchio. So those 2 courts are fully occupied by those 2 judges for various sessions. That makes the court to function with only 2 other courts to deal with incoming matters. And that is just not only Durban, if you go all over. So the difficulty is we have long trials and they are still coming. And we have fewer courts and fewer judges. So this backlog of criminal matters with these budgetary cuts, because we've now been told we have to reduce circuit courts because of the cuts. So it's going to just be more and more. So I just want to touch base on the criminal backlogs. Thank you.
Chief Justice.
Yes, so I just wanted to say that there are huge advantages post-COVID of getting courts online, because I know I'm from the Competition Appeal Court, and we are now entirely online for our appeals. So it saves on judges having to travel from another centre to come to a centre to hear a case, saves on hotel expenses, and everybody has access to it. So it works very well. We haven't experienced any problems. You know, occasionally there will be, because of load shedding, people will lose that, but it would have been a problem at the court in any event.
Thank you. Colleagues, is there anyone who wants to say anything about technology, Wi-Fi?
Yes, CJ, if I can say this
Yeah.
on behalf of the lower court judiciary.
Yeah.
We are also facing the same problem regarding the availability of Wi-Fi. We have raised the issue with the Department of Justice and Constitutional Development. It has been an ongoing discussion, but we hope that one day the issue will be addressed.
Okay. Thank you, Mbomvu. Lindo, I'm sorry, I'm taking over.
Thank you, CJ. Thank you, CJ. We also, on behalf of the lower court judiciary, wish you all the best as you will be retiring. We thank you for all the services, and we also wish the incoming CJ all the best too. And we also thank all the JPs, all the judges, the manner in which they deal with things. They actually teach us a lot in their judgments and everything. In our reviews, we get a lot of lessons that come from them, and we really appreciate it. Regarding the Wi-Fi, well, I agree with my colleague here of what he has said so far, but the department has also given us an option of not only relying on what they are installing in our courts. So they issued a circular where a magistrate can actually purchase the modem, data modem, up to 500 gigs in order to deal with whatever he might have a problem with regarding the internet connectivity. So the magistrates are allowed to do that, to purchase that, and then they are being reimbursed on monthly basis. So such that there is a lot of technology advancement in various courts. We now engage other stakeholders, like for instance the prisons, to have the postponements through using those Wi-Fi's, virtual hearings, and all other things, and even the interpreters from other places and witnesses from other places. In our recent meeting, we even engaged the department to make sure that maybe in each and every court, the court manager should be well equipped with everything, so that when a witness or maybe when an interpreter wishes to go and interpret somewhere else at the court where there is no interpreter, can simply go to that court manager's office and be connected virtually. And all this is possible through these advantages that we have been given regarding the 500 rands reimbursement scheme for the department. Thank you.
Thank you very much. May I go back to the JP? Then Linda will take over after that.
Thank you, CJ. I think the issue of the IT environment in the lower courts has been a problem. RCP Judge knows because he sits in Jade. I mean, we had to deal forcefully with an issue of recently appointed magistrates not being provided with laptops. That issue came to Jade, and we took it to the heads of courts when we met the minister to say this can't go on. So those issues are there, but we've raised them with the executive, and it's an ongoing discussion. But at the center of this, CJ, it's the independence of the judiciary. We have our domain and systems, IT systems. Justice has its own. Predominantly, the thinking in what applies in the lower courts is what the officials thought they want to implement there without engaging the judicial officers. That's been a problem that we've addressed. Say, if I'm going to use a system, don't think for me, come and ask me what I want to do. So that message is going through, and we hope with the new minister, new DM, things will go quicker than that, right? I wanted to deal with the issue of acting judges because I may forget it. I think Mr. Benjamin said the system of appointment of acting judges is opaque and no one knows what happens. The issue is you can't take the discretion of the head of court to look for people who must come and act in the division. You can't take it away from them. One of the recommendations in the committee's report is that the JSC should control that process. The head of court with his senior judges, her senior judges, are the best placed people to know what the court needs in terms of the requisitely experienced people who can come in and do the work. So the numbers that you see of acting judges being appointed is because you find judges going on long leave, judges going to act in other divisions, judges retiring. That creates big gaps. I feel it in Gauteng because I lose a lot of people all the time. But we also rely on pro bono judges because I can tell you now, had we not used pro bono acting judges, the lead times in terms of the hearing of civil trials would be longer than the 4.5 years you see now. So it all boils down to capacitating the courts with judicial posts that will deal with the work. It continues to increase, but the judicial establishment does not increase.
Thank you, JP. Let's see if we have another question. Is there no one else before I come back to you, Begezeni? Okay, there's no one else. Please proceed.
Yeah, I'll ask 2-3 more questions. But the report that we have this year is good in terms of what it tells us, but there's a lot of information that we are really not told, which we were told last year, which is an explanation for why there was underperformance. I know you mentioned some of it in your presentation, and it's included in the report. But one of the good things about last year's report is that it told us at each court what is the cause of the underperformance. And so I ask this because in the lower court section of the report, we are told up to quite detailed about the case flow blockages on what are the causes. So the question is, why is there such a discrepancy between what the lower courts report versus what the superior courts report? And maybe you can clarify that. And then the second question, Chief Justice.
Is it fine if I quickly answer that? If I may, you'll keep giving a chance before I forget. You see, the address that I delivered did not purport to contain everything that's in the report. So to the extent that I might not in that address have covered certain things, you might find that those things are in the report, in the report. But of course, it may well be that you are able to say that because you have looked at the report and you didn't find those things. The idea, as far as I'm concerned, should have been to reflect, as was done last year, for each court, because the explanations are not always the same, or they are not supposed to be the same all the time. So there might have been a challenge in checking that every court explains where it might not have done properly. So it's a pity the Chief Justice designate is not here so that she could make sure the next one improves on that. Thank you.